Hello, good morning everyone. Today we shall be discussing the case of State of Rajasthan versus Love Kush Meena. Good morning Saksham. There are, I guess, two people who have joined. Suman Shrestha, good morning. Suman. Good morning Aditya Prakash. Hello. Good morning Mehul. Good morning Soumya. So today we shall be discussing the case of State of Rajasthan versus Love Kush Meena. And this was the civil appeal number 3894 of 2020. On the bench was Justice S. Reddy and Justice K. Kaul. Date is 24th March 2021. Now the facts of the case. Good morning Chitralekha. Good morning everyone. So with this we start with the facts of the case. In the present instance, one of the respondents murdered the appellant's aunt in the field, and he and his mother and his other members also injured the appellant by stabbing them with knives. In the present instance, what happened? That one of the respondents murdered the appellant's aunt, in the field, and he and his other members also injured the appellant by stabbing them with knives. So actually the respondent and his aunt, they were there on the field, and her aunt was murdered, and this appellant was also injured after this appellant was stabbed with knives by the respondents. The defendants were then charged with criminal offences under the IPC. Sections 302, 323, 341, read with section 34. Now, following the investigation, the accused was served with a charge sheet which he vigorously rejected. Obviously, once the charge sheet is filed, then this is going to be opposed by the person against whom the charge sheet was filed, isn't it? Now, what were the sections under the charge sheet? Section 302. Section 302 is punishment for murder, because he had murdered the appellant's aunt in the field. Then section 323 of the IPC, this is punishment for voluntarily causing hurt. Whoever, except in the case provided for by section 334, voluntarily causes hurt shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine which may extend to 1,000 rupees, or with both. This is punishment for voluntarily causing hurt. Then comes next is section 341, isn't it? 341. What is there under section 341? Punishment for wrongful restraint, because there are two things, wrongful confinement and wrongful restraint. If you are restricting somebody's passage over which the person has a right to go, or right to travel upon, or right to tread upon, this amounts to wrongful restraint. Confining a person partially is wrongful restraint. Whoever wrongfully restrains any person shall be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 500 rupees, or with both. So this is wrongful restraint. Okay, this is wrongful restraint. And 34, what is section 34? Is it a penal section? Does this defines any offense and penalizes it? What is section 34? Yes, exactly, Chitralika. It's common intention. Acts done in furtherance of the common intentions by several persons. Okay, so it is not a penal section. It only creates common intention. That means it shall be deemed, if several persons are involved in a crime, then it shall be deemed. How we are going to fix the liability? Section 34 only lays down a rule of liability. Rule for fixing the liability in cases where several persons are involved in commission of one criminal act. And according to this rule of common intention, it shall be deemed that every such person individually committed that act. As if such person individually committed that act. So what is the rule? What is then the rule to fix the liability? That every person involved shall face the same charges, and he or she is going to face those charges and face the quantum of punishment in equal manner. Okay, so defendants were then charged with criminal offences under the IPC, section 302, section 323, 341 and 34. Following the investigation, the accused was served with a charge sheet, which he vigorously rejected. The experienced Yes, Prableen, everyone is held jointly liable under section 149 IPC. But there are some basic differences between section 34 and section 149. Section 149 talks about common object, while section 34 talks about common intention. And there is a difference between common intention and common object. Okay, mostly the things related, the crimes, the events, the incidents falling under section 149, they arise out of the unlawful assemblies. Okay, but section 34, common intention, is something which does not require any prior physical meeting or unlawful assembly. What is important with section 34 is the prior meeting of minds, which is possible even without a physical meeting. Okay, even without a physical meeting. The similarity between both the section is that they both hold the culprits jointly liable. Okay, but section 34 and section 149, they are different from each other because the former talks about common intention while the latter talks about common object. Okay, now following the investigation, after the investigation had begun, the accused was served with a charge sheet, which he vigorously rejected, like every defendant does it. This is done by like every person. The experienced judge later stated that the prosecution had failed to prove its case against all of the defendants beyond a reasonable doubt. The experienced judge, he later stated that the prosecution is not able to prove the case beyond reasonable doubt. Like before, since you are asserting a fact and you are bringing the case to the court, the charge sheet must be very strong. The charge sheet in this case must be very strong, because that's how, the experienced judge later stated that the prosecution had failed to prove its case against all of the defendants beyond a reasonable doubt. On the other side, A recruitment notice for the post of constable in the Rajasthan Police Services was published. Okay. On the other side, what happened? That a recruitment notice for the post of constable in the Rajasthan Police Services was published. These are published in the newspapers. The reply had applied for the position and had been hired after a successful interview. However, the reply was handed a letter claiming ineligibility for the aforementioned position after being verified by the police superintendent. After facing a very successful interview, this person was handed over a letter that he was ineligible for the aforementioned post after he was verified by the police superintendent. But this did not happen in the first instance. He was first called to the interview. His eligibility was not examined when he applied for the post. His interview was successfully conducted, but subsequently he was handed over a letter containing his ineligibility for the aforementioned post after being verified by the superintendent of police. According to the superintendent's letter, what was written in the letter? The respondent is ineligible for the position of constable since he has been charged with numerous major crimes. It came out after his background was thoroughly examined and reviewed. It came out that the constable, this person, has been charged with numerous major crimes. And following this rejection, the respondent filed a civil writ appeal with the Rajasthan High Court. And since his candidature was rejected after a successful interview, so he filed a civil writ appeal with the Rajasthan High Court. He filed a writ petition under Article 226 of the Constitution of India, okay, which the court dismissed in the first round. The court said that no, this needs to be dismissed in the first go because you are absolutely ineligible for the post because you are accused of committing major crimes. So following this rejection, the respondent filed a civil writ appeal with the Rajasthan High Court, which the court dismissed in the first round, citing the same rationale for being accused of such horrible acts. So that's how the story unfolds. That, on the other hand, like this incident was already happening, and in the meantime what was happening? Nikhil is asking who is reply. You will come to know. As we move ahead, do not confuse yourself. Here we are talking about a person who is accused of committing major crimes. Okay, and earlier in the first paragraph we have already read that there was a person who committed the appellant's aunt's murder and also injured the appellant after stabbing with the knives. Okay, so in the meantime, what was happening? There was another story that is running parallel to this. There was a recruitment notice in the newspaper for the recruitment for the post of constable in the Rajasthan Police Services. And this person had applied for the position and he had been hired after a successful interview. But subsequently, he was handed over a letter claiming his ineligibility for the aforementioned post after being verified by the police superintendent. Now, according to the superintendent's letter, the respondent is ineligible for the position of constable since he has been charged with numerous major crimes. Now, following this rejection, the respondent filed a civil writ appeal with the Rajasthan High Court, which the court dismissed in the first round, citing the same rationale for being accused of such horrible acts. Now, during the second round, the court referred to the police superintendent's letter, circular, and granted the petition, arguing that there is no solid evidence of the charges against the accused during the ongoing proceedings, and thus he should be allowed to apply for the position of constable in the Rajasthan Police Services. He filed a writ petition before the Rajasthan High Court. Before the Rajasthan High Court, claiming that he was earlier appointed, then he was subsequently dismissed. His interview was very successful. He was hired, and subsequently a letter came from the superintendent of police claiming the ineligibility of his candidature, and that was something very that was something uncalled for, and this should not have happened. So when the court inquired what was the ineligibility which was stated in the superintendent's letter, then when the court came to know that he is accused of committing horrible crimes, then the court rejected the writ petition in the first instance. Okay, now during the second round, the court referred to the police superintendent's letter circular and granted the petition, arguing that there is no solid evidence of the charges against the accused during the ongoing proceedings, and thus he should be allowed to apply for the position of constable in the Rajasthan police services. And now during the second round, the court said that no, after examining the police superintendent's letter, the court reached the conclusion that there is no solid evidence of the charges against the accused. Okay, because the sessions judge had already stated that the prosecution was unable to prove the case beyond reasonable doubt. The prosecution was unable to prove the case beyond reasonable doubt, and therefore it is important to make sure that the person who is simply accused and not convicted, who is not a proven criminal, okay, he can be hired, he can be given this job, arguing that there is no solid evidence of the charges against the accused during the ongoing proceedings, and thus he should be allowed to apply for the position of constable in the Rajasthan police service. Should be allowed to apply for the post of constable in the Rajasthan police service. The court outlined the requirements for the indicated positions appointment. The following were the requirements. Now, the court outlined the requirements for the indicated positions appointment. What are the criterions? What are the criteria for, for appointing a person to the post of constable in the Rajasthan police services? The High Court was trying to find out that he's simply accused of committing major crimes. His crimes are not proven yet. Even the court said that the prosecution was unable to prove the case beyond reasonable doubt. Right? The following were the requirements. After the closure report is approved, the person should not have committed any criminal offenses. After the closure report is approved, the person should not have committed any criminal offense. The defendant should be found not guilty by the court, whether under the benefit of the doubt or due to the availability of proof. Compromise resulted in acquittal or discharge. Section 12 of the Probation of Offenders Act 1958 was utilized. Section 15(1)(a) of the Juvenile Justice Care and Protection of Children Act 2015 accuses and benefits the person. I mean, if this is how his criminal history is going, then it's all right to appoint him as a constable in the police services. Okay, once the crime has been committed and the investigation has begun, and no proper evidence has been found, and the police has filed the closure report, and once that report is approved, the person should not have committed any criminal offense. After that, the person should not have committed any criminal offense. After the closure report is approved, the defendant should be found not guilty by the court. If the trial is going on, then the defendant should be found not guilty by the court, whether under the benefit of the doubt or due to the unavailability of proof. Okay. Third is, compromise resulted in acquittal or discharge. Compromise resulted in acquittal or discharge. Okay. Now, if there is a compromise that has taken place between the two conflicting parties, and this has either led to the acquittal of the accused or discharge of the accused. Can you please explain me the difference between acquittal and discharge? Do you have any idea about the acquittal and discharge? Please tell me. Now Nikhil says acquittal is after the trial is complete. Chitralekha says discharge is like they are removed from the trial. Ankita says acquittal release permanent. Chitralekha then says acquittal is proven not guilty. Aditya Prakash, discharge means removal of all charges. Discharge is temporary. Prableen says acquittal happens when judgment is pronounced and discharge happens during trial. Aditya Prakash says acquittal means proved not guilty. Baat Jazbato says acquittal is done after trial. Discharge is done if there is no case at the first instance. All of you have given very good answers. Okay, very good answers. There are various schemes for discharge under CRPC. And Ankita, I just want to correct you here. Discharge may also be permanent. Okay, discharge may also be permanent. Now the question is that acquittal is that once the trial is complete. Mehul's का comment आया है. Acquittal is a verdict in the criminal case that the accused is not guilty of the offence. Discharge is an order given by the magistrate. Yes, very good. Prableen says even before framing of charge, court can discharge under section 227 CRPC, but this is not the case with acquittal. Very good, Prableen. See, that's what I am telling you. That acquittal means that once the trial is complete and the court has found the accused to be not guilty of committing any offence, so he is acquitted. बाइज्जत बरी कर दिया कोर्ट ने, ठीक है, acquittal, acquitted, exonerated, right? But so far as discharge is concerned, for discharging the accused, the court does not have to wait for the trial to be complete. The court is empowered under CRPC under various schemes. There are various schemes for discharge under CRPC. One is under section 227. The other is under section 245. Okay. The magistrate is empowered to discharge the accused right on the very first day of the trial, if the magistrate finds no proper ground for conducting the trial further. Okay. It may be because of the absence of evidence. It may be because of the absence of grave suspicion. It may be because the magistrate finds it conclusive that the prima facie case is not made out against the accused. Okay. If the magistrate realizes that he has been wrongly implicated in the case and there is no evidence against him and there is no possibility of him committing this crime, there might be, any reason. These reasons are just limited by your imaginations. The only thing is that the magistrate has to record this reasonable ground for discharging the accused in writing. Okay, that's what you are supposed to do as a magistrate. Okay. Now Chitralekha says, sir, how is discharge different from quash? Quash can also be ordered against one single accused, right? See, quashing of the FIR or quashing of the proceedings, for that you will have to visit the High Court. If, for example, a complaint case has been filed against you and the proceedings have been initiated against you in a trial court, or an FIR has been lodged against you, so in such cases, if you cannot expect the magistrate to discharge you right away on the first day, you can move to the High Court under section 482 of the CRPC for getting your proceedings, criminal proceedings, or getting your FIR quashed by the High Court. Okay. Discharge takes place right at the trial level, but quashing takes place under the inherent powers of the High Court. Okay. Are you able to understand this difference? And quashing of the FIR or the discharge, they both can be done against one individual. It's not that for discharge you need to be in groups. No, that's not the case. Okay. Understood. So compromise resulted in acquittal or discharge. Okay. If the compromise has taken place and it has resulted in acquittal or discharge. Okay. Now section 12 of the probation of offenders, exactly, Chitralekha, the act is same. See, if the quashing is taking place, the High Court will simply record the reasons that because of the absence of the evidence and because of these grounds, we are quashing the FIR because the prima facie case is not made out. That's what exactly the magistrate does at the trial level during discharge. Okay. Now, compromise resulted in acquittal or discharge. If a person accused of any offense was accused of any offense and he has subsequently applied for a post of constable in the police services, but what happened in this case, in his case, was that a compromise was reached and his compromise either resulted in acquittal or his discharge by the trial court, then in such cases he becomes eligible again to, to be appointed for the post of constable in the police services. Or section 12 of the Probation of Offenders Act 1958 was utilized. I mean, there is a scheme under Probation of Offenders Act 1958 which lacerizes the the allegations. Okay. Then section 15(1)(a) of the Juvenile Justice Care and Protection of Children Act 2015 benefits the person. I mean, there are some beneficiary schemes under these provisions of these two laws. I mean, without going into the details of what these sections contain, it is now sufficient for us to ponder upon these 5 points, that if these 5 points are existing, then in such case the High Court has guided that a person can be appointed as a constable in the police services. Okay. It's not that if a wrong case was, you were maliciously prosecuted by someone, then your career is ruined forever. That's not the case. The High Court is trying to find some scope in your career also, that even if you are accused, if you have accused of any offense, but your trial or the proceedings have taken this trajectory, then it's all right, you can be appointed as a constable in the police services. Okay. So have you understood this? Now there are issues. What are the issues? Whether the respondent, having been involved in criminal proceedings and acquitted by the court on the basis of the benefit of doubt, is eligible for the post of constable in the Rajasthan Police Services public employment. Okay. Whether the respondent, having been involved in criminal proceedings and acquitted by the court on the basis of the benefit of doubt is eligible for the post of constable in the Rajasthan Police Service public employment. Okay, right? The respondent was involved in the criminal proceedings, then he was acquitted by the court. If you look at the chronology of the events, first he was involved in the criminal proceedings because he was accused of committing the murder of appellant's aunt, and he was also accused of injuring the appellant by stabbing knives. But when he was brought to trial, the trial court had acquitted him because of the lack of evidence and giving him the benefit of doubt. Okay, and subsequently running parallel to this was another story. Another story was that he had applied for the post of constable in the Rajasthan Police Service, but he was not appointed even after having a successful interview for the reasons of his criminal history. He was accused of committing major crimes. Okay, then the court deciphered quite wisely that he was simply accused of committing those crimes, and the trial court had acquitted him, stating that the prosecution had failed to prove the case beyond reasonable doubt, and he got the benefit of doubt. So he then becomes absolved of all those allegations and hence becomes eligible for the post of constable in the Rajasthan Police Service. So that was the question, that if any respondent having been involved in the criminal proceedings and acquitted by the court on the basis of benefit of doubt is eligible for the post of constable in the Rajasthan Police Service, because the state of Rajasthan was fighting this case against Love Kush Meena. The state was contending continuously that we have decided his candidature to be ineligible because he was accused of committing major crimes, and we do not think that he is fit enough, he's eligible enough to get appointed to the advertised post. But the question was that if a person is already acquitted by the Sessions Court, would you still call him a criminal? Would you still call him a criminal? Or do you think that once the court absolves a person of all his charges, would you like to see that person in the same manner as you used to see him before he committed that crime, because he was accused of that crime? The people, the society, the people develop their own perception. They develop their own perception of looking at a person who is accused of crime. So whether the respondent, having been involved in criminal proceedings and acquitted by the court on the basis of the benefit of doubt, is eligible for the post of constable in the Rajasthan Police Service public employment. So you now have to assure me that if you have understood the issue well. Understood or not? Please reply. Understood? Okay. Okay. Now, what are the laws involved? Section 302 of IPC, it's punishment for murder. Section 323 of IPC, punishment for voluntarily causing hurt. Section 341 of IPC, punishment for wrongful restraint. Section 34 of IPC, act done by several persons having a common intention. Section 12 of Probation of the Offenders Act, it's removal of disqualification attaching to conviction. Removal of disqualification attaching to conviction. Now I am going to read the text of section 12 of the Probation of Offenders Act 1958. It talks about removal of disqualification attaching to conviction. Notwithstanding anything contained in any other law, a person found guilty of an offence and dealt with under the provisions of section 3 or section 4 shall not suffer disqualification, if any, attaching to a conviction of an offence under such law, provided that nothing in this section shall apply to a person who, after his release under section 4, is subsequently sentenced for the original offence. That is simple. The rule is very simple. The matter of conviction brings with itself lot of disqualifications. If you have been convicted of any crime, you are not eligible for any government job. That's the simple rule. Because while filling up the form, you are asked under separate columns if you have ever been convicted of any crime. That's the simple rule. But once that allegation or that conviction is set aside and either you are acquitted or discharged, okay, then all those disqualifications attached with such conviction shall automatically be removed. Understood? This is section 12 of the Probation of Offenders Act 1958. That if conviction is bringing with itself lot of disqualifications, that you are not supposed to apply for the government job, you are not supposed to practice as a lawyer, you are not supposed to practice as a doctor, your license may be cancelled. These are just examples I am citing. This is not what exactly happens, but I'm just giving you an example. You become disqualified of doing certain things. Probably you may open up a shop. That's all you can do. But you cannot apply for a government job, no matter how qualified and how deserving you may be, because you have been convicted. But once that conviction is set aside, and you are absolved of all the charges, then all those disqualifications would automatically drop. All those disqualifications will automatically drop. Now, since you have been absolved of all those charges, you have now become re-eligible to go for a government job and apply for it and get hired and get appointed, with full audacity. You don't need to be, you don't need to be hesitant in applying for such jobs, because you have now been absolved by the court of law completely. All the charges against you have been dropped, and now you have a neat and clean history. Okay, so since you have become re-eligible for applying for a government job, you may go ahead for doing that. So section 12 is all about removal of disqualification attaching to conviction. Understood? Arguments of the appellant. Now, what the appellant was trying to state. The appellant's lawyer cited the case of Avtar Singh versus Union of India and others in 2016, in which the court established the standards for such instances. In this instance, it was pointed out that before making any judgments, the employer should follow the government's orders. Before making any judgments, the employer should follow the government's orders. If the individual is charged with a criminal offense or a crime of a particularly serious character, the employer should consider all relevant aspects of the case while determining the employee's employment. Okay? Before making any judgments, the employer should follow the government's order. The employer should follow the government's orders. If the individual is charged with a criminal offense or a crime of a particularly serious character, the employer should consider all relevant aspects of the case while determining the employee's employment. Okay. this issue must be resolved right at the time when the post is advertised, because these eligibility criterias should be listed out by the government in the advertisement very clearly and explicitly, so that the only the eligible ones who are whose candidature perfectly squarely fits into the eligibility criteria should apply for the post. Okay, that's it. The appellant's attorney has also cited previous cases in which the courts have collectively ruled as follows. An honorable acquittal does not imply that the accused was wrongly accused or that he or she had no criminal history. An honorable acquittal does not imply that the accused was wrongly accused and that he or she had no criminal history. State of Rajasthan was trying to prove that just because he was simply acquitted, that does not mean that he was wrongly accused and that he does not have any criminal history. He was given the benefit of doubt. And benefit of doubt is simply a failure on the part of the prosecution, but that simply does not mean that the accused never committed that crime. Okay. Second, for the position in the police force, a candidate must have high character, integrity, and clean antecedents. Okay. Not even a single blame should come on the face of the person who wants to be a police personnel. So for a position in the police force, a candidate must have a high character, integrity, and clean antecedents. Third, it was also argued that when making a hire decision, the employer should examine the job profile as well as the seriousness of the allegations leveled against the candidate. Okay. The employer, that means in this case the government was the employer, and while the government was hiring and it was making decisions, it is the job of the employer to examine the job profile as well as the seriousness of the allegations leveled against the candidate. Section 302 is a very serious offense, and it's crucial to determine whether the candidate's acquittal was a righteous acquittal based on reasonable doubt, or acquittal based on malice. So it's crucial, acquittal means that the court has acquitted and exonerated him because of the lack of evidence, but that does not mean that circumstantial evidence does not exist against him, or some evidence, howsoever weak, exists against him. So every acquittal may not be a righteous acquittal, especially acquittal based on reasonable doubt, where a person or the accused is getting the benefit of doubt. It is simply because of the failure or carelessness or callousness on the part of the prosecution. And this carelessness does not mean that the accused had never committed such crime, or acquittal based on malice. This may be one of the reasons. And last is, as a result, an acquittal in a criminal case cannot be considered part of police service. As a result, acquittal in a criminal case cannot be considered as part of police service. The person may be appointed in some other field, in some other department, but at least not in police. For being appointed in the police services, the person must have a very clean background. Not even false allegations must rise against him. He must not get into any notorious activity so that he may be blamed for anything, howsoever wrongfully it may be. Are you trying to get my point? So these were the contentions of the appellants. That's how was the state of Rajasthan was trying to put its points across. Okay. Then arguments of the respondents. The respondent's lawyer had backed up his arguments with a number of previous precedents. The respondent's lawyer had backed up his arguments with a number of previous precedents. The respondent was trying to defend himself, and he was trying to say that he is completely eligible for the post of constable in the Rajasthan police service. So respondent's lawyer was on his toes to prove that he is completely eligible. The following points were brought up by the attorney in such case. What were the points? The accused should be offered relief in cases when they have been acquitted. The accused should be offered relief in cases when they have been acquitted. Second, it was also claimed that work opportunities are rarely available in a country with such a large number of applicants. There can't be such mechanical and rhetorical formulations at such a time. Okay, the accused should be offered relief in cases when they have been acquitted. The point was very simple, that if the person has been acquitted simply straight away by the court, it means that the person was wrongly accused and he has a clean background now. Second, it was claimed that the work opportunities are rarely available in a country. We are already facing an employment crisis in a country. We have no jobs. People have nothing to, earn. It's getting really difficult in this country to earn for every person to earn their daily bread. And with such a large number of applicants. Now, if you are trying to bring some mechanical obstacles and hassles and rhetorical formulations based on rhetorical formulations, and these allegations are not even concrete, you are simply disqualifying the accused on mere suspicions, because your heart is not allowing him to appoint him. That's it. And these are just rhetorical formulations. These are not concrete formulations. Either he must have been convicted of the offense and his charges must have been proved. This could have been a concrete ground for the police to disqualify him altogether. But that's not the case. You are trying to bring mechanical and rhetorical formulations and trying to create hassles in his appointment at such a time. And third is that such situations must be scrutinized based on the facts of the case, the severity of the charges leveled against the accused, and so on. The situation must be scrutinized based on the facts of the case. The facts of the case is that he was completely acquitted by the court. He was accused of very severe charges, but still he was acquitted. So the counsel has also argued that there was a significant amount of time between the commission of the crime and the recruitment process in this case, and that the respondent was also successful in his competitive examinations years ago. The counsel stated that he had also appeared for various competitive examinations and he was quite successful in doing so. And there is a long gap when he was accused of committing the crime. The crime had, it's quite old, and the recruitment process is taking now. How far are we going to carry that? How far he is going to carry that stigma despite the fact that he was acquitted by the court? Okay. And lastly, the argument was that because there is no substantial evidence against the accused and the accused was acquitted by the court on the basis of the benefit of doubt, the respondent should give relief in order for the accused to be considered for a position in the Rajasthan Police Service. His argument was that he was simply acquitted. It was because there was no substantial evidence found against him and he was given the benefit of doubt, and he should be given relief in order for the accused to be considered for the post of constable in the Rajasthan Police Service. These were the contentions of the respondents. Now, judgment. The offence under section 302 read with section 34 of the IPC is non-compoundable. What is non-compoundable? What is non-compoundable? That means non-compoundable cases are the cases in which no compromise can be reached. No compromise can be reached. Some of the offences are compoundable. Hello? Can you hear me? Hello. Okay, there was a power cut, and the internet went away. The network is gone completely. There's some big fault in the power today. So I'm just wrapping this up now. The offence under section 302 read with section 34 of the IPC is non-compoundable according to the Court of Justice. Hence, it was impossible for the court to consider this case a clean acquittal. In such acquittal situations, the court has the authority to end the benefit of the doubt. In the case of the aforementioned Avtar Singh, the court said that when the act was heinous or of such terrible nature that the acquittal was based on reasonable doubt, the candidate could not be eligible based on such acquittal. Before conducting the selection process, the court stated that the employer should evaluate all government rules, orders, and instructions that apply to the employee. Okay, the candidate could not be eligible based on such acquittal. Since acquittal, the judgment of the court was very simple and clear, that since the acquittal was based merely on reasonable doubt, that simply means that it was the carelessness, it was something lack of preparedness on the part of the prosecution. And this does not mean that the defendant had never committed this crime. If prosecution is failing to collect to prepare itself properly for the case and collect the substantial evidences properly against him, that does not mean that the defendant never committed that crime. Okay, and looking at the seriousness of the offenses he was charged with, the candidate could not be eligible based on such acquittal. Before conducting the selection process, the court stated that the employer should evaluate all government rules, orders, and instructions that apply to the employee. Okay, now this was the judgment of the court. Now if you have any question or anything to add, you can do it quickly. Okay, only two people have understood. Chitralekha and Bajazwa Dodom. Okay, Saksham. Okay then, if you have understood and no questions, then I am ending the stream and signing off. And let's meet tomorrow.